Counsel first submitted that the evidence of the defendant's witness is not documentary. The witness was not at the 72 Special Forces Battalion as at 2014 when the incident took place. Hence, is not in a position to give evidence in respect of what transpired. The defendant have laid no evidence to prove that the claimant deserted the service of the defendant. Counsel finally urged the court to grant all the reliefs of the claimant for same having been proved. The defendant's reply was filed on the 28th of February 2020, wherein counsel rehashed his argument on Section 179 of the Armed Forces Act and further contended that the cases cited by the claimant's counsel in the final written address and Sections 126 and 167 of the Evidence Act do not apply to the claimant's case. Opinion of the court. After perusing the pleadings of the parties and the evidence adduced, and considering the submission of the respective counsel for the parties, the following issues will be apt in determining the case of the claimant. Number one, whether this court has jurisdiction to adjudicate on this suit having regard to Section 179 of the Armed Forces Act. Number two, whether the claimant has proved his case to be entitled to the reliefs sought. To the contention of the defendant on issue one, that by the provision of Section 179 of 4 of the Armed Forces Act, this court lacks the jurisdiction to hear the suit on ground that the claimant has failed to exhaust the internal remedies available to an aggrieved soldier before instituting an action. It is so well considered that jurisdiction is the life wire of any suit, and any action before a court which is found to be incompetent will touch on the jurisdiction of the court, which may lead to an order striking out the action. Simadokulo and Nkemdili, Abu and Kuyaba, Okolo and Union Bank of Nigeria, PDP and Okorocha. Similarly, jurisdiction is the power of a court to entertain and decide a case formally brought before it, which may be circumscribed by the law establishing the court, or the provision of the law requiring a thing to be done before the jurisdiction of the court can be invoked. See the case of SDP and BM. It is therefore imperative to consider the provisions of Section 179 of the Armed Forces Act and see how it has affected the jurisdiction of this court as submitted by the defendants. Section 179 of the Armed Forces Act provides that if a soldier, rating, or aircraftsman thinks himself wrong in any matter by an officer or by a soldier, rating, or an aircraftsman, he may make a complaint with respect to that matter to his commanding officer. If a soldier, rating, or any aircraftsman thinks himself wrong in any matter by his commanding officer, either by reason of his redress not being given to satisfaction on a complaint under subsection 1, or of any other reason, he may make a complaint with respect thereto to any Army, Naval, or Air Force officer under whom the complaint is for the time being serving, being an officer not below the rank of brigadier or corresponding rank. Or receiving a complaint under this section, a commanding officer shall investigate the matter and grant any redress which appears to him necessary. So to subsection 1 of this section, a soldier, rating, or an aircraftsman who feels he has been wronged in any matter shall first exhaust the administrative remedies available to him under this section before embarking on any other action. An initial complaint by the soldier, rating, or an aircraftsman to his commanding officer under subsection 1 of this section shall be made not later than 3 months of the wrong, in respect of which it is brought, and where the soldier, rating, or aircraftsman has not obtained the redress to which he thinks himself entitled, may make a further complaint in the prescribed manner. The authority prescribed under subsection 2 of this section, not later than 3 months of the complaint or of receiving the unfavorable redress as the case may be. No soldier, rating, or aircraftman should be penalized for having made complaint in accordance with this section, so far as the complaint does not contravene any provisions of this act. For more understanding of the case, let me also refer to the following paragraphs of the claimant's statement of facts. Paragraph 18, and I quote, the claimant advised that on the second day of April 2014, the claimant returned home from his duty post at about 6 p.m., only to meet the absence of his wife and their child that was living with them. And upon having a closer look at the house, the claimant found that his wife had removed all her belongings from the house and left with the child to an unknown destination. Paragraph 19, the claimant advised that 3 weeks after his wife had absconded to an unknown destination with the claimant's child, his wife resurfaced at Port Harcourt, making clandestine efforts to grab and abscond the claimant's child that was living with the claimant's brother in Port Harcourt, Rivers State, when she was accosted and both children taken from her and she left to an unknown destination. 20, the claimant advised that on the 6th day of May 2014, Lieutenant S.A. Oni, who was the then Adjutant Principal Secretary to the Acting Commanding Officer of 72 Special Forces Battalion, Lieutenant Colonel M.B. Madaki, summoned the claimant to 72 Special Forces Battalion Headquarters, Makodi, where the claimant was confronted with a complaint by the claimant's wife asking the army authorities to share the 2 children between the claimant and his wife. Number 21, the claimant advised that he informed the adjutant of the manner in which the claimant's wife absconded from the matrimonial home and how she attempted to abscond with the 2 surviving children of the marriage. Paragraph 22, the claimant advised that upon hearing the claimant's response in the matter, Lieutenant S.A. Oni stated that he was, as the Principal Secretary to the Acting Commanding Officer of 72 Special Forces Battalion, Lieutenant Colonel M.B. Madaki, directing the claimant to either give one of the 2 children to his wife or take back his wife. The claimant advised that he told Lieutenant S.A. Oni that his private and family life was not to be dictated by Lieutenant S.A. Oni, and that the claimant would not take directives from the said lieutenant regarding his private and family life. The claimant's position that he would not take directives from Lieutenant S.A. Oni on his private and family life made Lieutenant Oni furious, and he ordered Staff Sergeant Saadu Yakubu to detain the claimant in the guard room on the 7th day of May 2014, and the claimant was detained for 2 days. The claimant advised that upon being released from the guard room, the claimant pursuant to Section 179 of the Armed Forces Act, Laws of Federation of Nigeria, wrote a letter dated 29th day of May 2014 to the Acting Commanding Officer of 72 Special Forces Battalion, Lieutenant Colonel M.B. Madaki, seeking for redress against the claimant's wrongful detention by Lieutenant S.A. Oni. The claimants advised that upon receiving the claimant's letter seeking for redress against the claimant's wrongful detention by Lieutenant S.A. Oni, Acting Commanding Officer, Lieutenant Colonel M.B. Madaki, called out the claimant to his office, strongly admonished the claimant for seeking redress against Lieutenant S.A. Oni, and compelled the claimant to write apologizing to Lieutenant S.A. Oni. Paragraph 27, the claimant advised that out of fear of harassment and ill treatment from his commanding officer, the claimant involuntarily wrote a letter dated on 7th of June 2014 apologizing to Lieutenant S.A. Oni and submitted same to Lieutenant Colonel M.B. Madaki, who was not satisfied with the content of the letter of apology, and again compelled the claimant to write another letter of apology dated 4th July 2014. The claimant advised that by virtue of Section 92 of the Armed Forces Act, Laws of Federation of Nigeria, he was entitled to seek redress against the ill treatment meted to him by Lieutenant S.A. Oni, and the commanding officer, Lieutenant Colonel M.B. Madaki, ought to have inquired into the complaint rather than further ill-treating the claimant. The claimant advised that aside from refusing to inquire into the claimant's request for redress against Lieutenant S.A. Oni, Lieutenant M.B. Madaki deployed the claimant to permanent standby duty without break and wrote a letter to the Benue State University, Makodi, requesting the institution to expel the claimant, but the request was ignored. The claimant further advised that Lieutenant M.B. Madaki also sent a signal to a military police formation at Nigerian Army School of Military Engineering, Makodi, alleging that the claimant was harboring a foreigner in the military barracks at 72 Special Forces Battalion, Makodi. The claimant states that following the petition by Lieutenant M.B. Madaki, the military police detained the claimant for 7 days in his guard room at the Nigerian Army School of Military Engineering, Makurdi, before releasing the claimant for want of evidence to support the allegation that the claimant harbored a foreigner in the barracks. The claimant was detained in a disused toilet. Paragraph 2, the claimant advanced that further demonstrating desperation to mates ill treatment to the claimant, Lieutenant Colonel Madaki directed that the claimant be charged for secret redress against a superior officer, a Lieutenant S.A. Oni, against whom the claimant sought redress, but the one who read the charges, while Lieutenant Colonel M.B. Madaki passed the decision reducing the claimant's rank from corporal to lance corporal, plus a sentence of 14 days imprisonment with hard labor. The claimant advanced that being a corporal, the acting commanding officer, Lieutenant Colonel Madaki, had no powers to reduce the claimant's rank, as such powers raised with the court-martial in accordance with Section 257 of the Armed Forces Act, and that the circumstances under which the claimant's rank was reduced does not fall under the circumstances under which the claimant's rank could be reduced under the aforesaid Section 257 of the Armed Forces Act. The claimant advanced that when he was brought before Lieutenant M.B. Madaki, the acting commanding officer, to answer to the trump-up charges, the claimant objected to the summary trial and requested to be tried before a court-martial in accordance with the existing laws, but not before his accusers. That's Lieutenant S.A. Oni and Lieutenant Colonel Madaki. But the claimant's request was ignored. The claimant advanced that he drew the attention of Lieutenant Oni and Lieutenant Colonel Madaki to the effect that by virtue of Section 179 of the Armed Forces Act, Laws of Federation of Nigeria, a soldier cannot be punished for seeking redress, but the claimant's statement before S.A. Oni and Lieutenant Colonel Madaki were ignored. The claimant advanced that less than an hour after Lieutenant Oni and Lieutenant Colonel Madaki charged and found the claimant guilty, Lieutenant Colonel M.B. Madaki handed over administration of 72 Special Forces Battalion Makurdi to Brigadier General T.A. Labaja, who was then a colonel by rank. The claimant advanced that on the 18th day of July 2014, Brigadier General T.A. Labaja, who was then a colonel, went to the guard room where the claimant was serving a sentence of 14 days imprisonment with hard labor, and directed that the claimant be brought before him. Brigadier General Labaja and the claimant was so brought. The claimant advanced that Brigadier Labaja threatened the claimant that because the claimant sought redress against the colonel of an officer, he, Brigadier General T.A. Labaja, would ensure the deployment of the claimant to the northeast at the slightest given opportunity so as to prevent the claimant from obtaining the law degree that was being pursued by him at Benue State University. Also, Brigadier General T.A. Labaja stated that he will use the claimant to sanitize the Nigerian army. And lastly, paragraph 39, the claimant advised that when he completely served the 14 days imprisonment with hard labor, Brigadier General T.A. Labaja again deployed the claimant to permanent standby duty without break. The claimant was not permitted to have his bath or go feed. From the foregoing paragraphs, it can be observed that the claimant earlier sought for redress under Section 179 of the Armed Forces Act against his wrongful detention by Lieutenant S.A. Oni to his acting commanding officer of 72 Special Forces Battalion, see Exhibit RAY7. However, the acting commanding officer admonished him for seeking redress against Lieutenant S.A. Oni and compelled the claimant to apologize to Lieutenant S.A. Oni. The claimant also stated that his acting commanding officer alleged that he harbored a foreigner in the military barracks at 72 Special Forces Battalion, Makurdi, while the military police detained the claimant for 7 days in his guard room before releasing him for want of evidence. That the acting commanding officer also directed that the claimant be charged for seeking redress against a superior officer, where the commanding officer, Lieutenant Colonel M.B. Madaki, passed a decision reducing the claimant's rank from corporal to lance corporal, plus a sentence of 14 days imprisonment with hard labor. From the above facts stated by the claimant about his ill treatment because he sought for redress in accordance with the law against his superior officer, I do not think that with those kinds of ill treatment the claimant had passed through, it will be expected by the defendant to seek for redress again against his commanding officer before coming to court on these claims. In paragraphs 39, 38, and 39 of the claimant statement of fact, the claimant continued to receive the threat and ill treatment from Brigadier General T. Labaja, fifth defendant, because the claimant sought for redress against his superior officer. The claimant also stated under cross-examination that Brigadier General T. Labaja issued an order to the soldiers to execute him whenever they got to the battlefield. And the fifth defendant allocated his apartment to a soldier who was junior in rank, but not allocate another one to him. In the case of Uwanko, a Nigerian army given, it was held by the Court of Appeal per Amadi J. while interpreting Section 178 of the Armed Forces Act, which is similar to Section 179 of the said Act, that a compulsorily retired army officer is not affected with the provisions of Section 178 of the Armed Forces Act. See also Nigerian Army and Hassan, where the Court of Appeal in its considered decision upheld the decision of the National Industry, choosing to strike out the case on Section 178 of the Armed Forces Act. I need to state that the action of the defendants of penalizing the claimant when he sought for redress against his superior officer was contrary to Section 1796 of the Armed Forces Act. Hence, the defendant cannot invoke the provisions of the said section to contend that the claimant did not exhaust the internal mechanisms before instituting this action. Suffice it to say that he who comes to equity must come with clean hand. By Section 6 of the 1999 Constitution, the judicial powers vested in the court shall extend to all matters between persons or between government or authority, and to any person in Nigeria, and to all actions and proceedings relating thereto, for the determination of any question as to the civil rights and obligation of that person. See Section 6 sub 6b of the 1999 Constitution. To me, the claimant's right to institute this action cannot be taken away by the provision of Section 1794 of the Armed Forces Act in the circumstances of this case, as his earlier effort to seek for redress against his wrongful detention was met with strong admonition, ill treatment, and threats. Let me quickly state that in the case of Nigerian Army and Hassan Supra, the Court of Appeal has hinted the point that the appellants cannot raise for the first time in their final written address the issue of condition precedent under Section 178 of the Armed Forces Act without earlier raising the issue in their pleadings. I observe in this case that the defendants only raised this issue of the claimant not exhausting the internal mechanism for the first time in their final written address. The issue was never raised either in the defendant's pleadings or by a notice of plenary objection. I wish to add that irregularities either arising from defects in the originating process or arising from failure to comply with the condition precedent is waivable at the expense of the defendant to allow the proceedings to be heard on merit. See the case of Ogwanyi and Nikon Insurance PLC. In the light of the above, therefore, I have no reservation assuming jurisdiction to hear this case on its merit. Issue 1 is accordingly resolved in favor of the claimant against the defendant. Having resolved issue 1 in favor of the claimant, I shall now proceed to consider the second issue. It is settled principle of law under our jurisprudence that the onus is on the person who asserts to lead credible and convincing evidence in support of that which he asserts before he must succeed. See Section 131, 132, and 132 of the Evidence Act and the case of Apostle Peter and Registrar Trustees of Saviour's Apostolic Church of Nigeria. The first 5 reliefs of the claimant are declaratory, and he has to lead cogent and credible evidence to show that he's entitled to the declarations. So, thus, an admission by the defendant does not relieve the claimant of the onus placed on him to prove his claim, and the said reliefs are never granted as a matter of course, but the reliefs are obtained on the basis of very strong and cogent case contained in the claimant's pleadings and evidence laid in support. See the case of Akimbadi and Babatunde. The claimant is trying to establish his claims, testify for himself, and tender 13 exhibits. The first 3 reliefs, A, B, and C, are about lack of fair hearing during the summary trial of the claimant by the defendant and the reduction of his rank from corporal to lance corporal respectively. Claimant averred in his pleadings that when he was ordered to be detained by S.A. Oni for 2 days, He wrote a letter seeking for redress against his wrongful detention to Lieutenant Colonel M.B. Madaki. But the said Lieutenant Colonel Madaki, after compelling him to apologize, directed that the claimant be charged for seeking redress against a superior officer. And ironically, Lieutenant S.A. Oni, the person against whom the redress was sought, was the one who read the charges, while Lieutenant Madaki, the person to whom the redress was addressed, passed the decision reducing the claimant's rank from corporal to lance corporal, plus a sentence of 14 days imprisonment with hard labor. That the claimant also stated that Lieutenant M.B. Madaki had no powers to reduce his rank as such powers raised with the court-martial, and that the purported reason under which his rank was reduced does not fall under the circumstances in which his rank could be reduced according to Section 257 of the Armed Forces Act. See paragraphs 25, 26, 27, 32, 33, 34, 35, and 36 of the Statement of Fact. In response to these arguments and the evidence given by CW1, the defendant only denied the allegations of maltreatment, admonition, ill treatment, deployment of CW1 to a standby duty without break, denied writing to the Benue State University to expel CW1, and the defendant did not instruct anybody to detain or constitute any panel whatsoever to reduce the rank of the claimant. See paragraphs 8 and 9 of the Statement of Defense. However, the evidence of CW1 as to his ill treatment, summary trial, and reduction of his rank was not demolished during cross-examination. And I find that the ill treatment on the claimant is reprehensible, and the entire process leading to his reduction of rank violates the established principle of fair hearing. The fair hearing principle is so fundamental in any proceedings that breach of it will vitiate or nullify the whole proceedings. Once the court comes to a conclusion that there is a breach of the principle of fair hearing, the proceedings cannot be salvaged as they are null and void ab initio. Fair hearing lies in the procedure followed in the determination of the case and not in the correctness of the decision. See the case of Orubo and Bulara. It is evidently established by the claimant that the attitude displayed by the officer of the defendant raised a case of bias against the claimant. It is shown in this case by the claimant that there's real bias against him, as the officer of the defendant demonstrated hostility and ill treatment against him. The action of the defendant infringes upon one of the twin pillars of the established rules of natural justice. That is, and I quote, you cannot be a judge in your own cause. After all, Lieutenant Colonel M.B. or Madaki do not even have the power to reduce the claimant's rank. Section 257 of the Armed Forces Act states as follows. I'll skip it. It was advised by the claimant in paragraph 1 of his Statement of Fact that he is at all material times a corporal in the Nigerian Army and that he was enlisted into the service in August 1997. See also paragraph 8 of the Statement of Fact. I'm certain that the evidence as put up by the claimant is compelling and persuasive. It has remained uncontroverted and unchallenged. Hence, I'm bound to act on the same. See the case of Usman and Abubakar. I need to also refer to exhibit RAY1A, Statement of Account of the claimant, which shows that the claimant was receiving a monthly salary of 57,000 naira. This tallies with the statement of the claimant under cross-examination as the monthly salary of a corporal. CW1 stated under cross-examination that his salary was as a corporal was 56,000 naira. Following from the above, therefore, I found that the claimant was at all material times recognized by the defendant as a corporal. Hence, reliefs A, B, and C are granted. Relief E is that the refusal of the defendant to proceed the claimant's application for voluntary discharge was unlawful and a breach of exhibit RAY 9. In his evidence, the claimant stated in paragraph 43 of his deposition that due to that wide range of the ill treatment meted out on him, he applied for voluntary discharge from the Nigerian Army on 3rd of September 2014, having served for 18 years and in line with the provisions of exhibit RAY 9. DW1 in paragraph 14A of his deposition denied having the application for voluntary discharge of the claimant in the defendant's custody. Under section 02.04 of part 2 of chapter 2 of Exhibit RAY9. It was stated thus, and I quote, initial engagement for all soldiers, ratings, or airmen shall be for a period of 10 years regular service, after which the soldier, rating, or airmen could voluntarily discharge, unquote. The claimant in paragraph 9 of his deposition stated that he was enlisted into the service of the Nigerian Army on the 18th day of August 1997. But the defendant in paragraph 2 of their deposition merely denied this assertion and stated through DW1 during cross-examination that it's not correct that an officer can apply for voluntary discharge from the Nigerian Army after 10 years. That a soldier who will apply for voluntary discharge is to only serve for 18 years. I need to state that the assertion of DW1 under cross-examination is at variance with the provision of section 02.4 of Exhibit 9, already produced above. The law remains established that a document speaks for itself. Hence, the provision of section 02.08 of Part 2 of Exhibit 9 cannot be altered or varied by the oral testimony of DW1. See the case of Baliol Limited and NAPCON Limited. A cursory look at Exhibit 2 with the two annexes shows that it was a reply dated 8 September 2014 from the admin company of the defendant, signed by one E.S. Robinson, Major OC, to the application for voluntary discharge made by the claimant. The application for voluntary discharge is the first annexure to the reply, and the second annexure is the form for discharge, pensions, and gratuity assessment soldiers, which was filled by the claimant. These sets of exhibits clearly bring to light the fact that the claimant applied for voluntary discharge, and it was responded to by E.S. Robinson, on behalf of the admin company of the defendant. From the above, it's clear to say that the provisions of Exhibit 9 make provision for voluntary discharge of a soldier after 10 years of service. This enabled the claimant to submit Exhibit 2, which led to the application for interview to the commanding officer as contained in Exhibit 3. The interview was partly done as seen from Exhibit RAY4, but there's nothing to show if the voluntary discharge was so approved and conveyed. Consequently, reliefs E and I are hereby granted. Reliefs D and F are for orders of the court for unpaid salaries from December 2014 to November 2018, and for monthly salaries until judgment. I have considered the evidence presented in support of this special haircut claim, which is Exhibit 1. This exhibit reveals that the claimant was last paid salary in November 2014. However, the claimant admitted during cross-examination that, and I quote, the last day I was placed on duty was the last day I fled, which was 11 November 2014. I was paid my salary in the month of November 2014, unquote. It's clear that the claimant left the service of the defendants on the 11th of November 2014. It's rather curious why the name of the claimant keeps appearing on the nominal roll and postings as contained in Exhibit 8, dated 3rd February 2017. Exhibit RA11 and Exhibit RA12, dated 12 April 2016, when he stated that he had fled from the service of the defendant due to ill treatment. The defendant had claimed in the evidence through DW1 that it was a typing error. This is most curious for a typographical error to continue up to 3 years after the claimant had left. Whatever it is, the most pivotal issue is whether the claimant actually discharged his duties between November 2014 to the time of filing this suit in December 2018. The claimant himself has not let evidence show that he continued to work after he fled the services of the defendant on the 11th day of November 2014. He said this in paragraph 60 of his deposition. And I quote, that being without a residential room in the 72 Special Forces Battalion Headquarters Makodi Barracks, I'm becoming fully aware that Brigadier General T.A. Labaja was bent on eliminating me. I fled from the 72 Special Forces Battalion Headquarters Makodi Barracks to Gedo Village, Boko Road, Makodi, Benue State, on the 11th of November 2014, where I've been living till death. unquote. There's no evidence that the claimant was discharging his duties from his Gedo village residence. Can it be said that the claimant deserves to be paid salaries for the period of December 2014 to date of judgment in absence of any evidence that he continued to discharge his duties after he fled in November 2014? I think not. Payment, because payment of wages is for work done. I therefore do not find merit reliefs D and F. Relief H is for payment of 4,929,400 naira as value of household items, cash, books, medals, and sundry items carted away from the claimant's room by the defendant. The claimant has pleaded and made depositions as to the value of the items found in the official quarters occupied by him. The claimant has stated that he had no receipts for this item because the receipts were also taken away by the defendant. The claimant is in evidence contained in paragraph 54 of his deposition stated thus. The claimant denied taking away the properties. The defendant denied taking away the properties of the claimant and reallocating his room to another officer. During cross-examination, CW1 stated that he did not see the fifth defendant cutting away his properties. Besides the allegation that the fifth defendant moved the claimant properties and reallocated his room, there is no evidence showing who actually moved the properties. The claim for this item are special heads of claim, which must be pleaded and proved with credible, convincing, and cogent evidence. Special claims cannot be granted by mere asking. See cases of Ajibotosho and R Construction Company Limited, Union Bank and Alhaji Adams Ajabuli. Therefore, this relief to me fails and cannot be granted. Consequent upon the above, it must be noted that the success or otherwise of each case depends on the evidence presented by the claimant who desires a particular outcome. While some parts of the claimant's reliefs are not sufficiently proved by evidence, but others succeed. At any rate, claimant's case succeeds only in part, and I hereby order as follows. Number one, a declaration that the purported summary trial and reduction in rank of the claimant from corporal to lance corporal, from corporal to lance corporal by the officer of the first to fourth defendant, Lieutenant Colonel M.B. Madaki, is a breach of his right, is a breach of the claimant's right to fair hearing, guaranteed by the rule of natural justice, and therefore null and void. Number two, a declaration that the claimant is at all material times a corporal. Number three, a declaration that the refusal of the defendant to process the claimant's application for voluntary discharge is unlawful and a breach of the terms and conditions of service guiding relationship between the parties. Number four, that the defendants are directed to process and approve the voluntary discharge of the claimant in line with Exhibit 9 within 30 days of this judgment. The defendant shall, upon the discharge of the claimant, compute and pay his gratuity, pension, and other benefits accruable within 30 days of this judgment. Number six, reliefs D, F, G, and H are ever refused and dismissed. Judgment is entered accordingly with a cost of 500,000 naira in favor of the claimant against the defendant, which shall attract 10% simple interest per annum when it is fully liquidated. Yes, Oha.
We appreciate the court for the well-considered judgment. I know we shall be praying for cost of 200,000 as
I've already awarded 1,000. It's contained in judgment. I awarded 500,000. Oha.
Yes, my lord.
I say I've already awarded 500,000.
Yes, my lord. I got that from the judgment. But the
So
200,000 is cost for appearance and other legal fees.
The defendant's counsel, Mr. Onati, is still not here. Oha, thank you so much. You are discharged.
Accomplices.
Yes. Mrs. Okon.
Yes, my lord.
Call that other case. So I'll just quickly. But
Okay.
fine.
Okay, my lord. Suit number NICN UY NICN MKD 14/2013 between Ifeanyi Azikiwe and Main Street Bank Limited. My lord, parties are absent in court.
Yes, Mr. Enebele. Are you here? Mr. Enebele. Mrs. Awazim.
I'm here, my lord.
Yes. Mr. Enebele is not here, ba?
He was here earlier, my lord.
Okay, let me just record your appearance. PC.
Awaziyama. Awaziyama, spelled A.
Yes.
For the defendants, my lord.
Yes, for the defendant, yes. So,
thank you.
Miss Awaziyama, I'm going to skip some things. So,
Very well.
yes, I'm going to skip. It's not everything that I'm going to read.
Very well.
The claimant suited this action by a complaint and other accompanying processes. Okay, sorry. So, by a further amended complaint with other accompanying processes filed on the 21st of November 2018, the claimant seeks the following reliefs as endorsed on his further amended statement of fact against the defendant. Number one, a declaration that the suspension and or dismissal of the claimant on 2nd of August 2011 and 10th of December 2011 was unlawful, null and void. Number two, a declaration that having served the defendant for 20 years, that's 24th 10, 1999, 1991 to 10th of February 2012, is entitled to be paid his service gratuity, which in details are stated in paragraph 28 above, totaling 21 million naira. Number three, a declaration that is entitled to his half salary of 7,000 naira, amounting to 43,750,000 naira, amounting to 250 in the period of total claim is 21,504,000 naira paid by Main Street Bank. Okay, less 2.2 million naira paid by Main Street Bank Limited after serving them the writ of summons sometime in or about 2024. Number five, general damages for mental and financial hardship suffered over the years, having served the bank for 20 years without benefit. In response to the claimant's amended processes, the defendant via leave of court granted the 20th of March 2019, filed amended statement of defense with other accompanying processes in urging the court to dismiss the claims as put up by the claimant. A perusal of the pleadings filed by the claimant reveals that he was employed in 1991 as supervisor by the defunct Afri Bank PLC, which later metamorphosed to Main Street Bank Limited, Sky Bank, and now Polaris Bank Limited, as he worked in several branches of the defendant and enjoyed promotions. The claimant stated that he was transferred from Kaba branch to Makodi branch in 2011. He discovered that the bank has lost most of our valued customers. In order to woo them back and improve the financial base of the bank, he lobbied some of the customers who had left the bank by offering two of them overdraft facilities for their businesses. However, on 5th August 2011, the claimant received a letter of suspension for 6 months without payment of half salary as contained in the collective agreement. And while he was on suspension, he received a letter of dismissal from the defendant. The defendant in her defense stated that the claimant, upon his transfer to Makodi branch of the defunct Afri Bank PLC, gave out two credit facilities to two different customers to the tune of 21 million naira without authorization from the management and in breach of the standard operating procedure of the defunct Afri Bank, that one of the customers was already owing the bank to the tune of over 15 million naira, hence the disciplinary procedure and subsequent dismissal of the claimant for act of gross misconduct. The defendant contended that due procedures as laid down in the rules of the defunct Afri Bank Nigerian PLC were complied with, and fair hearing was accorded the claimant before his dismissal. Trial, I will skip the trial, I will skip the exhibit, the cross-examination, then final submissions. Final submission of the defendant raised 3 issues. Final submission of the claimant raised 6 issues. Then the reply, defendant filed its reply to the claimant's final written address. Then the decision of the court. I have carefully looked at the processes filed by the parties, their evidence, exhibit admitted, and their respective submissions. While the defendant formulated 3 issues for determination to defend this case, the claimant formulated 6 issues to argue his case. However, I will adopt with some modification issues 3 and 5 submitted by the defendant and the claimant respectively, as the issues appear similar. The issue state thus, and I quote, where the claimant has proved his case to be entitled to the reliefs sought. Before delving into the merit of this case, let me address some lingering issues conversed by both parties. The claimant has in his submission raised objection to Exhibit 10, which according to the claimant is a public document made by an interested party, and Exhibit PB34A and B, for being photocopies of photocopies of public documents. The argument of learned counsel to the claimant is that Exhibit 10, which is the purchase assumption agreement between the NDIC and the Polaris Bank, was made by an interested party during the pendency of this suit. The exhibit was made on 21st of September 2018 in a bid by the current defendant to acquire the Alien Sky Bank Limited, former defendant. The claimant commenced this suit on February 20, 2013 against the now defunct Main Street Bank Limited. And while the suit was ongoing, Main Street Bank was acquired by Sky Bank Limited, leading to an amendment of the court processes on the 13th of October 2015. However, on the 1st of September 2018, while the matter was still before the court, the current defendant, Polaris Bank, equally acquired Sky Bank Limited, thereby necessitating another amendment of court processes upon order of the court made on 20th November 2018 to make Polaris Bank a defendant. The objection by counsel is hinged on Section 3 sub 3 of the Evidence Act 2011, which state as follows, and I quote, "Nothing in this section shall render admissible as evidence any statement made by a person interested at a time when proceedings were pending or anticipated involving a dispute as to any fact which the statement might tend to establish," unquote. Now, can Exhibit 10 made between the defendant and the NDIC on 1st of September 2018, which was about 2 months before the defendant was made a party to this suit, be said to have been made in anticipation of this suit? The order of court making Polaris Bank as defendant in this suit was granted on 26th of November at the instance of the claimant, and the processes were amended to reflect the new defendant thereafter. As the then defendant, Sky Bank Limited, applied to reflect the name of the Polaris Bank on 20th March 2019. By the decision of the Court of Appeal in let me take it back again. The two underlying conditions are when proceedings are pending or when proceedings are anticipated. As regards the application 3 evidence, now Section 3 sub 3 of the evidence, let me say straight off General rule and law is that documents made by an interested party during the pendency of a suit is inadmissible. This section is connected, render inadmissible a document prepared by an interested person in order to defeat through its clear wordings the cause of justice. Such a document is rendered inadmissible when the maker knows about the pendency of the suit to which the document is made. And even when he does not know about the existence of the suit, he anticipated the dispute might arise. Supreme Court, by the large JSC then, in the case of UTC and Lawal, has defined this interest thus. The interest that is envisaged by the law, which disqualifies, is a personal interest, not merely interest in an official capacity. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest in the legal sense, which imposes something to be gained or lost. Or lost. So following from the above, I do not hold the view that Exhibit 10, which was made over 2 months before the instant defendant was made a party to this suit, fits into the ambit of section 3 sub 3 of the evidence. This line of objection is hereby overruled. Another limp of the objection by learned counsel to the claimant is that Exhibits 3, 4A, and B, which are photocopies of public documents, were not duly certified in accordance in complying with Section 104 of the Evidence Act 2011. Section 104 is hereby reproduced. Exhibit 3 is a CTC of the winding up order of the Federal High Court Lagos, while Exhibit 4A and B are Main Street Bank Limited banking license and certificate. I've carefully perused these 3 exhibits. Exhibit 3 bears a seal of the certifying officer as H.J. Obaha, Mrs. Chief Registrar of the Federal High Court Lagos. This exhibit seems to be a photocopy of a certified document. In the Supreme Court case of Magaji and Nigerian Army, copies of a document certified in accordance with Section 104 can be said to include a photocopy. Thus, needs no further certification. See also the case of ACB and Modika. There is, however, no evidence of certification on Exhibit 4A and 4B as required by Section 104 of the Evidence Act. However, this court, being empowered by the provisions of Section 12 of the National Industrial Code Act 2006 to depart from the provisions of the Evidence Act in order to do substantial justice between the parties before it, I will therefore overrule the objection by counsel to the claimant to Exhibit 3, to Exhibit 3, 4A and B respectively, and hold that the documents be relevant, remain admitted in evidence. Let me just Miss Nwazia Ziama.
Yes, my lord.
Let me just go to the end.
Very well, my lord. My network is very bad.
Okay, yes, let me quickly go to the end.
Okay, my lord.
So the claimant before this court has not established by sufficient evidence that his dismissal was contrary to the provisions of the terms and conditions of his employment as contained in Exhibit 7, as to be entitled to the general damage. On the whole, it's evidently clear that the claimant has not, by evidence presented before this court, established the wrongfulness of his dismissal or entitlement to any gratuity or damages. The defendant has alleged that by the provision of Bit 10, which is the purchase assumption agreement executed on 1 September 2019 between the NDIC and Polaris Bank Limited, the defendant did not acquire liabilities of Sky Bank Limited as regards contract of employment or trade union action. Thus, it is not liable to pay any sum of monies to the claimant. The claimant, in response to this assertion, has posited that the defendant acquired both assets and liabilities of Main Street Bank Limited and Sky Bank Limited, hence is liable to pay him his entitlement. However, the claimant has not laid evidence in this regard. I've carefully read through the content of Exhibit 10 and paragraph 2.1 titled, and I quote, liabilities assumed by assuming bank, which reads, in consideration of the transfer of the asset contemplated herein, the assuming bank expressly assumes at book value, subject to adjustment pursuant to Policy Clause 7, agrees to pay for discharge of the following liabilities of the failing bank as of the effective date, except as otherwise expressly provided in this agreement. Such liabilities referred to as liabilities assumed, litigation liabilities to the exclusion of litigation liabilities arising out of trade union actions or contract of employment. This provision is concise and clear that the now defendant before this court has not brought over the liabilities of this suit. On the totality of the determination of the issues raised on behalf of the parties and consideration of the facts and circumstances of this case, I'm of the view that the case of the claimant is found to be unmeritorious and ought to be dismissed. Accordingly, it is hereby dismissed. Judgment is entered accordingly with no order as to cost.
As a class, please.
Yes.
My Lord, we are moving for the work of the judgment, and we appreciate the court for the industry putting. My Lord,
Thank
I don't
you.
know how we the judgment.
Eh?
The copy of the judgment, how we'll be able to access it.
We'll send it, Mr. Peter, our divisional registrar. I will send it to Makodi for you.
Very well, my Lord. We are most grateful.
Thank you. Okon, which one is the next case?
My Lord, we have Michael Ukwe.
Okay. I don't know whether the counsel in the case of Michael Ope are here. Mr. It's like it's only one person that is present. Mr. Eche. Mr. Eche, you are muted. Mr. Eche, you are muted. Mr. Eche Apoko, you are muted. Or mute yourself. Yeah, just stop that mute. Touch that mute. Touch it. Mr. Eche. Unmute yourself, Mr. Eche. Do you have any younger person around you? Yes, call them now. Those digital this thing. Okay.
Hello, my lord.
Yes, Mr. Eche. Good morning. How are you?
Yes, I'm fine, my lord.
Well done.
Yes, sir.
Which case are you?
We are in the case of Simon Terungwa Kwave against Corporate Affairs Commission.
Okay, you are representing the defendant or the claimant?
Yes, the defendant, sir. I'm representing the defendant.
Why the counsel? Okay, why the counsel for the claimant? So that we'll just adopt the written addresses and.
Yes, sir. The counsel is Mr. Kelvin Yuzenda.
Okay, why is he?
I think he's in the meeting because I cited him earlier.
Okay.
I think it.
Can you try him on phone, please, so that I said, can you try him on phone? Just try him. Try to call him on phone so that we'll.
It's okay. Just a minute, my lord.
Okay, thank you.
I can't get him. I can't connect him.
Huh?
I can't connect him now.
Okay.
Hello, good afternoon, my lord.
Okay.
We can't see you.
Yuzenda is back in court.
It's the network.
Yes.
Good morning.
Good afternoon, my lord.
The network. Yes. Good afternoon. You're welcome.
Yes, my lord. Thank you, my lord. Sorry, the network threw me out of the meeting. I had to rejoin again.
Yes, it is so poor today.
Yes, my lord. My name is Kelvin Yuzenda.
Okay, for the claimant?
Yes, my lord.
Okay. Yes, Mr. Eche.
Yes, I am Eche Akoko for all the defendants.
Okay. Yes, Mr. Kelvin.
Yes, my lord.
Yes. The matter is for adoption.
Yes, my lord.
It's like there's a pending application, no?
My Lord, we are ready for adoption.
Okay, is there any pending application?
My Lord, I do
I
not
think-
have any pending application for the claimant's final written address. There is no pending application, my Lord.
There is none.
Okay.
There is none, my lord. Yes.
Okay, that's none.
Yes, yes, my lord.
Okay, Mr. Eche, you can start.
It's okay, my lord. My lord, upon the conclusion of the hearing, the defendants filed a final written address
Yes.
dated 10th November 2020. Dated 10th November 2020 and filed on the 13th November 2020.
It's dated.
It is dated 10th November 2020
And filed.
on the 13th November, 2020.
Yes.
My Lord, upon the receipt of the claimant's reaction by way of his final address,
Yes.
the claimant again filed a reply on point of law.
Claimant or
A reply
defendant?
on sorry, the defendant, sorry. The defendants
Yes.
filed reply on point of law, that is on the 26th November 2020. And we adopt both addresses as our arguments and submissions in this matter.
Okay.
Yes. My Lord, by way of adumbration,
Yes. 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 Yes, Mr. Che. Yes, Mr. Che. Yes, Mr. Che. Okay, we've also lost him. I'm sure he'll be back. God willing.
Well, my lord, I think Mr. Eche has adopted. I think he wanted to just adumbrate, but the main thing has been done.
That's what he wanted to do, yes.
Yes, but I think he has adopted. So I don't know if in the circumstances I can also go ahead and adopt. I'm not going to adumbrate.
Okay, then after your adoption, then we adjourn.
We adjourn for him to adumbrate or what, my lord?
No, I don't think so. Yeah, that's what I'm saying. Should we, after you adopt, then we wait for him to rejoin to enable him adumbrate or what?
No, my lord. Even if sometimes, even if you are in court, you must.
Yes, or if you can try him on phone and. It's this network issue. Yeah.
Excellency Dr.
Yes, my lord, I just got Mr. Iche on phone.
Yes.
Yes, he said he has just finished adumbrating, so I can go ahead. But he said he's still trying to rejoin if he can.
Okay.
Yes, sir.
Okay, so you want to proceed? You want to go to
subject to the court's convenience, my lord.
Okay.
Yes, sir.
Okay. Yes, I think you can go on so that if he's able to join, then I can hear his I can listen to his adumbration.
Okay.
So yes, so the claimants, okay, he has also adopted his reply bar.
Yes, he has adopted all his addresses.
Okay, his claimant's final written address.
Claimant's final written address is dated 16th of November 2020.
Yes. Yes.
It was filed on the 26th of November 2020.
Okay. Yes. Yes. Yes, Mr. Kelvin. Yes.
Yes, my lord. My lord, we most humbly adopt claimant's final written address in urging your lordship to enter judgment for the claimant and grant all his relief sought before your lordship in the interest of justice.
Yes. So, Mr. Kelvin, the claimant didn't didn't join any other person that he thought the death benefit of his sister.
Sorry, I didn't get that, my lord.
I said the claimant did not join, like in your relief number C, relief C. It's like, okay, relief number 1. Number B, sorry.
Yes.
Declaration that being the rightful next of kin of late Miss Mercy, the claimant and no one else is entitled to the group life benefit, pension, death benefit, and others. There, relief C also says Another of this honorable court notifying payment of the late Miss Messi Ungwangwan, group life benefit, death benefit, and any other entitlement by whatever name called, accruing to, and in her name to any other person, if the payment has already been made by the defendant to any. Okay. So it didn't want to know those persons.
My lord, we didn't join.
Oh yes, you didn't join them.
Join them because what we are saying is that if we don't know, so we are saying that assuming it was done, then it should be nullified. But we didn't know. All we are saying is that my client is the one that should be paid everything. So, but in the event that any other person has already been paid, that is why we are saying that should be nullified.
But it's like in the course of the proceedings, because the father to the deceased came and testified. It's like one of them received something. One of the purported and
yes,
next thing received something, but
yes, my lord, all these things are the cutting of corners that we are saying. That all of these,
and you feel you don't need to join that person that was said to have collected whatever benefit given to him by the first defendant. You feel that person that that did collect.
My lord, we do not have any issue against any other person. We have an issue with Corporate Affairs Commission and the parties that we came to court against.
Yes, but is it the only is it Clement who is the only next of kin of the?
Yes,
of
in
the
record of CAC which they have, that was the rightful person that was given to them by the late Messi Ngungwan. She gave CAC the next of kin, which is our client. So if they breached it and went ahead to pay any other person, we are not privy to that. They didn't consult our client. Our client didn't authorize that they pay to any other person.
But what about this change of name of next of kin that the CSC presented? They say,
my lord, it was never done. They forged it, and we demonstrated that before the court. My client never did it. They are the ones that are claiming after everything, because they hid a lot of monies that were supposed to be paid, and now brought a peanut and paid to the father, and allegedly paid to the father. So that is exactly what we are saying.
Okay, that document was forged.
My lord, whether it was forged or not, the rightful person that was before the court, that the records of CSC showed, was our client. Is our client.
If you are pleading that it is forged, I want to know from your pleadings where.
No, my lord, our case is already as before the court and adumbrated in our final written address. It is because my lord asked about that I was trying to give some insight. Yes. Our case, the evidence is before the court, and all our arguments are as contained in our final written address.
Okay. And we urge the court to grant all the reliefs. So I don't know.
My lord.
What are we going to? I don't know what to do. Are you going to wait for Mr. Ete, or we are going to come back on Monday for the adumbration? Or should just straight away?
My lord, Mr. Eche has finished, and like I told my lord, I also called him on, for he has adopted all the addresses.
Okay, so she just adjourn for judgment.
For judgment, I was even thinking the judgment was ready, my lord.
No, to be ready on, and it will be ready next week.
as the court pleases. So my lord, if we are coming back, it should be for judgment because we have finished
yes.
adoption today.
Yes,
my lord.
That is why I was asking you some question to I've not yet formed my any opinion.
Yes, my lord, the truth about it is that our client is the rightful person that CAC has his records as the next of kin of his late sister. But along the line, they were even the ones.
CAC came and tendered another document saying that the deceased changed their next of kin.
My lord, we even challenged them to bring out the records, their own records that they have. They never did. What they brought that contained that document was never given to them. When my client's sister died, they were the ones that called him, come, you are the one with our... So is it at the point after she died that she now changed documents with them? Because they were the ones that told him to come.
But Mr. Kelvin, I can remember that under cross-examination, your client was, he even confirmed it, that he was asked to come along with his father. But he didn't. No, my lord. He went there alone. And when he also went to Abuja alone, they asked him to go to Abuja with his father, but he didn't go with the father. It's like under cross-examination. Anyway, I'll go through it and see.
Well, I think my lord has the record. The court has the records, but
yes.
Yes, they were dealing with him alone. The only thing at the point at which there became a problem was when he asked them how much is the sister's entitlement, that they got angry. If not, they were dealing with him without any other person, because on record, it is my client that was the next of kin. So reasonably, the dead person couldn't have resurrected to change her records with the CAC, and then they will call him and then change it halfway. And because they are the ones that have those records, they never produce them, even when we challenge them to produce them before the court. They have a register. We kept saying, bring that register, let us see. They didn't.
Okay.
Good afternoon, Lord.
So it was because they thought they wanted to defraud the young man that they now went and gave the father peanuts, and the man collected and started saying, I have been paid. When we asked him under cross-examination, how much is your daughter entitled to? He couldn't say. How much did you collect? He couldn't say. So they avoided the rightful next of kin to go and deal with someone else so that they would chop the entire money. That is the problem. That is the only problem in this suit, my lord.
Okay. It's like I had a... Yes, Mr. Echi. Are you back?
Yes, my lord, I'm back.
We can't see you, but we can only hear you.
Oh, yes. I can also hear the voice of my lord. I can't see him too.
We can see him now, my lord.
You said you wanted to do the adumbration.
Yes. So I was saying that... Yes, what I wanted to say, or what I was telling the court then, was that for the claimant to proceed in this matter, he must have to establish his status as the next of kin to the deceased.
Yes, that's what he said. He has established that. He said he has established that he's the next of kin of the deceased.
Yes, my lord. And as with CAC 2, A and B. Clearly,
which one is that?
As with CAC, that is the record as to change of the next of kin.
Okay, change of next of kin.
Yes, sir. The record has before the court.
He said that it was false.
The records are before the court.
Okay, what about the gazette? The gazette.
Sorry?
The gazette.
Gazette as to.
Yeah,
the
gazette is, the gazette.
Yes, the gazette is in sorry, sir. The gazette is in respect of the PRA, that is pension scheme with premium pension.
Okay.
Yes, That asset is
not the whole,
exactly,
okay, not the other benefits.
Not a CS, not a debt benefit with a CAC. The gas covers only her pension benefit with pension premium. This in account.
This document, for change of next of kin, is it Exhibit 7 and 8 or what?
I think it says with CAC 2, A and B.
Okay.
As with CAC A and B. Clearly, you will see that the claimant is not her next of kin.
Okay.
The claimant is not the next of kin to the deceased.
Okay.
Yes. Okay. And as to who was being dealt with, it is not true that my learned friend Kelvin was trying to mislead the court.
What did he say?
To the deceased, yes, he said the CSC was dealing with him, and that is not true. The father to the deceased confirmed that message was sent to him from CSC, and he instructed the claimant to go and act with them. That was how they sent this burial money to him. It was on his instruction.
On the instruction of the father.
Yes, sir. That was his evidence before the court.
But Mr. Clement is saying that even the father couldn't actually know how much was the entitlement of the deceased.
It was.
Yes,
my lord.
That the defendant only wanted to deal with the father because they can give him anything. The father can accept anything. But if it were the claimant, since you know the actual amount, they may not they will not want to deal with the claimant because the actual amount.
My lord, that is criminal allegation. It's criminal for them to be alleging that the father knew how much was paid to him. And in any event, the amount is even before the court. So it was not even lying the amount of the father to begin to tell the court. The amount is before the court. The father didn't deny that fact.
Okay, so okay.
Yes, sir.
So,
my lord, I don't know if I will say something, my lord.
Yes, you can say it now. He has also said something.
Lord,
you can say,
my lord. If my lord takes a look, I invite my lord to take a critical look at that Exhibit CAC 2. Even that change of next of kin was done, even assuming it is even true. It was from the claimant to one Dese Henry Kwave, not even the father. May the court take a look at Exhibit CAC 2.
No.
Even that change that they brought, that CSC brought, was done from the claimant to one Dese Henry Kwave and not the father. It is before the court, and I invite the court to take a compassionate look at it.
Yes.
Okay, so if it was changed, just hold on, Mr. Chair. You spoke and I didn't interject. If it was changed,
no, you are misleading the court.
Yes, I can hear you, Mr. Kevin. Go on, yes.
Yes.
I can hear you,
invite the court to take a look at that exhibit. The name here is from Teungwa Kwave to Dese Henry Kwave, not the father.
What is the title of the exhibit? What is the caption of the exhibit? Is it this declaration as next of kin or what?
No, I think it's a copy of the internal memo, request for additional and change of next of kin.
Okay.
That's the document I'm referring to.
Okay, CSU 2.
Yes.
Yes.
If my lord looks at the original next of kin, it's the claimant, and then the one that is purported to be changed is Dese Henry, which is the claimant's brother and not the father. So at what point was it changed to the father that the father had to go and claim the money? or they are trying to deal with him. And then I mentioned earlier that when everything was happening, they were dealing with the claimant. But because he knew the amount that was supposed to pay.
Okay, but Mr. Kelvin.
Yes, my lord.
If we are going to go by these exhibits, that is CAC 2A, the internal memo. If we are going to go by the annexure, the next of kin is the former next of kin is Mr. Kokbe Terungwanba.
Yes.
And the new one is Mr. Kwakbe Dese Harry. So it means going by this, the claimant was no more the next of kin. If we are going to go by this.
Yes, that is what we are saying. Yes, that is what we are saying. That assuming they are even claiming that it was changed, why didn't CAC deal with Mr. Dese and why didn't they deal with Mr. Dese, but they prefer to deal with someone who is not even mentioned in that document at all? Doesn't that show intention? Yes,
my lord.
That is the point we are raising, and it is very critical, my lord.
Allow him to.
So hold on now. You had your day. Just hold on. So even if we are doing that same document, sir, Mr. Kwave is not mentioned anywhere. So why on earth will they now prefer to go and deal with him? Why? Assuming we are to take that the claimant was somehow changed.
Yes.
Which we are not even considering at all.
Okay.
So assuming we are to concede, Mr. Dese would have been the one to collect all the money. So why would CAC now go to deal with a different person that is not mentioned, whether as former next of kin or as current next of kin? That shows something was wrong somewhere, my lord. That is the point we have been stressing.
Yes, my lord.
Okay.
Yes, my lord.
Yes.
From the of the document, the latest next of kin to the deceased are Kwave, the father. Then you have Henry Dese, the brother. They are on the face of the document. Kwave,
no, from which document? From which document?
From which document? I mean, SBCAC 2A and B. SBCAC 2. That change of next of kin. You have Kwave, the father.
Why is that? It's Mr. Kwabe Terungwamba. Why the father's name?
Is the claimant.
Yes, it's the claimant. Why the father's name written?
Why the father's
name?
My lord, it is nowhere.
Why the father's name written?
Let me trace the document and refer my lord to it.
My lord, it is nowhere. It is nowhere at all. That document has Kwave Simon Teungwa as the other next of kin, and the current one, which they are claiming, is Kwave Dese Henry. So the father's full name is Boo Godwin Kwave.
No,
and you will not see Boo Godwin Kwave anywhere.
Sorry, Mr. Kevin. Look at what it says. It says Mr. Kwave, father, then Dese Harry, brother. Two persons.
Very well, my lord.
Yes, Mr.
Very
Kwave,
well, my lord.
Father, then Dese Harry, yes, brother.
Yes, brother.
Yes,
thank you very much, my lord. That is our point.
That's what is written.
And see, that's
like
misleading.
Like if you can look at number one is Onoja Mukasa Shaibu. They say Mrs. Priscilla.
Mukasa. Priscilla. Yes.
Wife, Ayuba, son, brother. In the case of Abraham Abdul Kadir, he has Abdullah, son. In the case of Agaku, Barnabas, only one person, son. But in the case of Messi Kwakbe, there is Mr. Kwakbe, father, then
Yes.
they say
Henry, brother.
So there are two persons there.
So what was
in any case, I will look at it. I'll look at the whole thing.
My Lord, I want to clear a wrong impression, my Lord.
Yes, what's that?
That Mr. Kwakbe that you see there has Tengwa down, and that is the name of the claimant. Mr. Kwakbe, that is up, is the second name is down, which is Mr. Kwakbe Tengwa. And so we the former next of kin. So the next new next of kin is now Mr. Kwakbe Dese Henry. My Lord, the name of the father is Kwakbe Boo. And not Tengwa or Dese.
Okay, Mr. Kevin, if that's the case, why did they indicate or put the names of two persons, father and brother?
My Lord,
against the two names,
my Lord,
in the next column there is father and brother. Kwakbe,
very well, sir.
Henry, brother. If there's only one person, why should they have put father and brother? It should just have been brother. In any case, I will look at
yeah,
everything.
my Lord, we just invite my Lord to take a critical look at the documents. There was a lot of fishy that the people we have joined, Mr. Ruben Aka and Oyeni Mrs., they are the ones that caused all these things. And that's why we joined them personally. Because the money my client was supposed to give him, they turned it into something else and gave the father peanut and bought him over, and which is not supposed to be so. So if my Lord takes a critical look at the documents, my Lord will discover that a lot of waters pass under the bridge, and we have to go to court. Because my Lord is also a civil servant. My Lord, all the next of kin is always the same, where they are paying your death benefits and even pensions. So why is there a difference now between the one in pension and the other one? So he collected the one for pension, but they somehow cleverly schemed him out of the life benefits. So my Lord, that's what we are saying. Because they have the record and they doctored all the records.
So
we asked them during hearing, we asked them to bring that register that they have of all the people who are entitled to be paid. My Lord, they never produced that register. It is in our written address. They never produced it till today.
My Lord, I don't know whether we are making oral submissions now, because there is no amount of sentiment that can change the content of the documents that are before the court.
My Lord, on the whole, we are inviting my Lord to enter judgment for the claimant.
How many times will I adopt? How many times will Kevin adopt?
Is next Friday okay for you?
I was not even going to adumbrate. Mr. Eche was the one that wanted to adumbrate. I adopted and went my way.
22nd of
then you started making submission more than adumbration.
22nd of March, is that okay?
2nd March.
Friday.
Okay, next
22nd.
Is that okay?
My Lord, Monday would have been better, my Lord. Monday.
No, Monday I'll be having. Which Monday?
Subject to my Lord's convenience, but 22nd is not convenient, my Lord.
Is it not for judgment?
So second is a Friday.
Yes, sir.
It's not okay for you.
Yes, sir. It's okay by me. It's okay by me. It's for judgment.
My Lord,
like by 4 o'clock. Mr. Kevin, isn't it okay by 4 o'clock?
My Lord, 4 o'clock is fine. 4 is fine.
Yeah, by 4.
4 p.m. is fine by me, my Lord.
Yes, 4 p.m.
Thank you, my Lord.
Is that okay, Mr. Eche?
My Lord, we are most grateful. Very well, my Lord. Okay. And thank you for your indulgence.
Thank you so much. So,
thank
cases are adjourned to the 22nd of March 2024 for judgment by 4 p.m. via Zoom.
As the court pleases. Thank you, my Lord.
Thank you so much. So, gentlemen, it's like the other council did not join in the other matter. So, in the absence of any other thing, I wish you a very good afternoon.
Thank you, my Lord.
I rise. That will be all for today.
Thank you.
Thank you, my Lord.
Thank you. Okay, bye-bye. Thank you.
Kelvin.
Bye-bye.
Kelvin.
Yes, sir.
It's better you come and see Baba here.
I will call you. I will call you in camera, sir. Off camera,
okay,
sir.
No problem. No
Thank
problem.
You,
no problem. You're welcome.
Thank you, sir. Thank you.
So,